the unconscionable part from a technical standpoint comes into play after the contract has already been executed. So it's not something that happens beforehand. So the question of, the fact that you determine that it's unconscionable afterwards, or you're arguing that it's unconscionable, is kind of how it all plays out in a practical matter anyway. So what happens is that typically I would have somebody that would come into my office and say, hey, I've got this contract. I'm unable to perform or unwilling to perform my terms because this contract is unconscionable because of X, Y, and Z, or it's unfair. They use other terminology. And so I would take a look at it. One of the things that you can do is to inform the other side that the contract is unconscionable and you're not going to live up to the terms of the contract because it's unconscionable in nature, or you may live up to some of the terms that are within the contract, but not all of them, because some of the terms may be conscionable and some may be unconscionable. So that is probably the most inexpensive and the easiest way if the two parties can kind of hash it out, and one side says it's unconscionable, but we're willing to maybe do X, Y, and Z, and the other says, well, we'll do X and Y, but not Z, and you kind of, you negotiate after the contract has been signed. Typically it's beforehand, but if there's something where you can argue that there's unconscionability on one side, then the other side may be able to convince the other party that a judge or jury may in fact determine that the contract is unconscionable and unenforceable, and so there's negotiations that take place from that perspective. The other thing is that at least in Florida, the party that deems it to be unconscionable can file suit and ask for a declaratory judgment from a judge, which was basically to say that we know there's going to be an issue and you have to meet certain criteria to get a declaratory judgment, but assuming you meet those, you basically say to the judge, we want you to declare our rights and obligations, and our obligations should be less than what the contract asked for because it's unconscionable in nature. So you certainly can file suit and go that route if you determine that the contract is unconscionable. And kind of the third way is to basically let it play out and take a defensive action. So you don't file suit, but you basically tell the other side that we're not going to, it's always a good idea to notify them as opposed to just not performing, to notify them and say, look, we're not performing, we're not negotiating, we're just not doing this. And if you want to sue us, that's fine, because we'll defend it on the argument that it's unconscionable. And if we win, we'll ask for attorney's fees and costs, and the other side may decide not to pursue it. So those are basically the three most common options.